industry.
So they're saying to you, stop at a red light and stop at a green light.
Exactly.
So you're stuck.
Exactly.
And you're looking to your constituents and your obligations to them. Would that be a fair way to put it?
Yes.
Exactly.
Sure. I think the other aspect that we haven't really got into is, Act 13, as it stands right now, if it were to go into effect, would allow the PUC, which is a branch of the executive branch, to review local ordinances that we passed. South Fayette ordinance that we passed 2 years ago, which permits drilling activities, but only in certain districts, only in industrial areas, certain commercial areas, but doesn't permit it in residential areas, doesn't permit it in conservation districts. That ordinance were deemed by the PUC to be invalid under Act 13. That throws everything for a loop. I mean, that would conflict with our municipality's planning code, our comprehensive plan, which sets forth zoning areas and where certain activities will be permitted and where they won't be permitted. All that's up in the air. So I think the court is also looking at the ability of an executive branch to usurp the authority, judicial authority. In other words, they're exercising a judicial authority as a branch of the executive branch. Can they review ordinances? Can they deem ordinance to be invalid or not invalid? That's at issue here as well.
And another point on that, Darren, what you're talking about, if they do go ahead and declare it invalid, then you not only have to pay the attorney fees for the other side because you've lost, you also lose your impact fee that they're putting out for the state too. So it really makes it hard for a community to challenge just because you're going to roll the dice. If you lose, you don't just lose your zoning in that area, you lose a lot of money with it too.
Let me ask you about that question too. Much is made of the impact fee. But I also was looking at some numbers based on the new act, and there's only a couple of wells in Allegheny County. Fortunately, we've been a little bit slow to develop, I think largely because of density of population in and around the metropolitan area. What happens if you have 2-3 wells? I mean, I think there was a number of 39,000 of impact fee coming to Allegheny County, and I'll stand to be corrected on that one. But I think it's that amount. Have any of you looked at what you're all being drilled in your municipalities right now, South Fayette?
No, we haven't had any
None yet.
drill sites. We have about approximately 1/3 of our township that it's leased to drilling
So what, about
companies.
4,000 acres?
So we're yes, at least 4,000 acres that we're
Okay.
aware of. So I mean, we're sort of on the cusp of it. We're dealing with these issues now. We haven't experienced it firsthand as Robinson Township and Cecil Township to some extent.
So about
They've had more-
25% of your township is already leased out.
Yeah, I mean, the part that really brought this whole thing to light for us was around our school, which is in a residential area. There are 5 residential developments, and we learned 2 years ago that Chesapeake had amassed leases for about 600 acres, including some school district property that we were unaware of. So that's what really brought this issue to a head for us. We passed our ordinance, and now, through the evolution of events, here we are having to defend our ordinance and also having to challenge the state law that would invalidate our rights to local governance, our rights to pass such an ordinance.
So, but Robinson, are you being drilled, Supervisor Coppola?
Yeah, we have quite a few wells in Robinson Township, along with a small processing plant and compressor. But we haven't looked as much at the impact fee as we have at the zoning, but just some of the basics. There are caps on that impact fee, and I believe it's either half of your annual budget or $500,000. And to put that in perspective, $500,000 will pave about 2 miles of road. The impacts are far greater than that.
Right.
Just our experience in the last 4 years, that wouldn't even begin to cover the damage that's done to our roads.
So,
We don't have as many wells as what Brian has in his community there, but we have some wells in Cecil
you
Township.
stand to get some impact fee here money, but I guess that's the big thing is that, again, they talk about impact fee, but they really don't get into a specific number. And maybe statewide it might seem like a lot of money to some people, but when you get down to what's actually flowing into a municipality, it's relatively not a lot of money when you consider what the operations of a local government are. It's not like a windfall.
No, not compared to the actual impacts. In fact, it's a lose. It would definitely be a lose for us and I'm sure we would have to cut back on services because of all the impacts. In addition to that, the impact fee, that money can only be used for specific things. And one of the things that they have targeted is low income housing. And when we asked our representatives and senators to clarify what do they mean by low impact housing, and he said basically that's housing for gas workers. So as far as remediating some of the damage that's caused by the drilling, the roads, some of the infrastructure, that would never cover it, at least not in our township. It would be a lose for us.
So you mentioned with the start of this was you said, well, you might lose your impact fee. In the grand scheme of things, it's not like 50% of your budget went out the window as a revenue.
No, and I think initially in House Bill 1950 or the Senate bill, there was the option where if you did not amend your ordinances and you kept your zoning as is and kept your protections, you would not receive the impact fee. Well, we immediately said we would keep our zoning because that's much more important protection of the residents than an impact fee. And as time went on, that of course was removed from the bill, so people don't have the choice anymore.
Yeah, I remember Senator Scarnati did an op-ed piece, I think in 2011, and inferred that, you know, those communities that choose not to allow drilling in their communities, then you wouldn't get an impact fee. And when I read that, I goes, oh, we have a choice. You know, it's like, fine, I'll forego the fee. Well, you guys go do your thing, we'll do ours. But that option was taken off the table.
I think they woke up because they actually got to see the fact that there was a lot of communities that say, the zoning is so important to us, we need that we'll opt out of the impact fee right away.
Right.
So that was why.
That's not possible.
And now it's not possible.
All right, so you've had a couple of victories too. You went into court. You had some people that wanted to kind of clog up the case a little bit with the interventions. The judge said, what did he say? You know, how did the judge react to that?
Well, I wasn't there for the proceeding, but
Yeah.
my understanding is the judge, based on what the attorneys have told me, the judge did not respond kindly to the attempts to, influence the litigation. I think it seems as if the judge at that time, is the senior judge in Commonwealth Court,
It was
very,
Judge Quigley, I guess, Justice Quigley.
very
in
thoughtful, very
yeah.
conscientious. He wants to get to the merits of it. He's, we're encouraged that he'll give this case a very fair and full hearing, although there will be a whole panel, what they call en banc, where there will be a panel of Commonwealth Court judges hearing it. My understanding is that Judge Quigley will be part of that panel. But we're encouraged that they're holding a hearing specifically on the motion for summary judgment that we filed. Municipalities filed a motion saying essentially that the law is so clear under the facts that are presented that we're entitled to a judgment in our favor at this juncture. So that's what the hearing on June 6th actually is, motion for summary judgment.
So you had the intervener, and I think, and you got the injunction. So you're so far so good on your end of the legal score sheet. You had two major issues here. One, the judge granted injunctive relief, a stay for 120 days, and then he also precluded other third parties from coming into this.
The important thing to me, Doug, about the injunction is the fact that it does give us a chance to run this through the court system. It also did give us the opportunity to go through and look at our ordinance and have a consultant go through and see how much you'd have to change, because there is the opportunity, the fact that you might not win it. So if you don't, then you are in a position, what are we going to have to do as a township if this doesn't work out for us? What are we going to have to change? So it gives you the opportunity to prepare for all outcomes.
All the contingencies.
Exactly.
Well, that's interesting. And as I said, it is a landmark case. It's engendered a tremendous amount of interest in the legal community. I've been looking on the internet, and it's in a lot of different legal sites, or basically lawyer sites that are informative, the bar associations, and other more of a neutral party just tracking this. I am sure it has garnered a lot of attention. What next? June 6th is the hearing on the summary judgment.
Yes.
So that if the judge finds that you guys are right in your briefing and everything else, that the fundamental basics were wrong, what happens to the state?
Well,
I mean, they got a lot riding on
well,
this.
from what I understand, and Darren could probably clarify it for us, there's an automatic appeal to the Supreme Court, I believe. So I'm sure it's going to end up in the Supreme Court. And the judge was also very clear on how big of a piece of legislation this was. And he repeatedly said, this is major legislation, this is a major issue. So the court was very interested in expediting this, moving it along very quickly. But I'm sure that it will be appealed by either side to the Supreme Court. What we were concerned about and why we really went for the injunction as quickly as we did is if it took effect on April the 14th, there would basically be a period of no law in Pennsylvania. We had nothing on the books. Act 13 prevents us from really putting anything on the books quickly and of any substance. So you would have these gas companies with free reign throughout the state. So we were very concerned. We were very happy to get the injunction. We felt very confident we would get the injunction.
The Supreme Court, I know it's unwise to try to plumb the thinking of our justices, but they did make a stand in 2009 in the Huntley versus Oakmont case. In my humble opinion, I think that's what led to Act 13, was not so much what Pittsburgh ban did and other people, more restrictive zoning ordinances and so forth. But in that case, the Supreme Court basically said that both of the things, the Municipal Planning Code and the Oil and Gas Act, do the same thing, and it's public safety primarily. Keeps things safe. But they noted that the zoning was also the ability of a community to define its character. You no longer can define your character.
That's right.
That's right.
And Supervisor, you're a lawyer.
Yeah. And I think that's...
Is the Supreme Court going to walk away from a decision they did in 2009?
I would hope not. We feel strongly that precedent, legal precedent is on our side, which fundamentally, from a legal standpoint, is a very important thing to have court precedent that is on point and favors your position. So, we're confident that the Supreme Court will take into consideration the Huntley case very closely. You raised an interesting point, too, about municipalities like the city of Pittsburgh, Borough of Baldwin, Forest Hills Borough, that have passed bans within their municipality on hydrofracking. Just wondering.
Yeah, Homestead, West Homestead. I think,
there's a list.
Yeah, there's a number of
them.
State College had a referendum and it was overwhelmingly passed to prohibit it as an activity.
Yeah, and Act 13 says expressly that these activities, drilling activities, are permitted in every single district. So the fate of those ordinances that ban is also in question at this point in time. It's probably at issue. It's not what's at issue directly in regards to our municipalities, but it's also an issue there of local control, what municipalities are able to do, what they're not able to do. Passing, are all those ordinances now out the window? That seems to be the conventional wisdom if Act 13 were permitted to stand as is. So, we're hopeful and cautiously optimistic that, that we'll get a fair hearing. There'll be a judgment rendered in our favor at the Commonwealth Court level and the summary judgment. That will be upheld by the Supreme Court. But simultaneously, there's also efforts underway in the legislature, in the Pennsylvania House and Pennsylvania Senate, to amend Act 13 to restore local zoning powers to municipalities. So I think that's also important, given there was a very close vote when Act 13 passed, as Brian alluded to in February of 2012. The vote was very close, and you still have representatives and senators that believe that municipalities should not be stripped of their zoning powers and their police powers. So I think that's also something that's at work here. So there could be a judicial solution. There also could be a legislative remedy to correct this wrong.
We have no illusions about how the world works. Obviously, the industry put a lot of time, as they said at the hearing, time and money and effort to get this law. And that, that's not unusual. A lot of campaign contributions and whatnot. I always say it's always fair to ask. It's a question of who's giving. Giving back whatever it is that you're requesting. Do you think the governor overreached on this one and Senator Scarnati overreached in trying to please the industry?
I really do feel they overreached in it. I was there whenever Judge Quigley made his, we had the court case in Harrisburg. And I really felt that with the zoning part of it, they did overreach. If